call. We're going to go ahead and record this. Welcome, everybody. My name is Eddie Chavez Calderon. I am the campaign organizer here at Uri L'Tzedek. Happy to be here with everyone. We have a great event today with our great friend, Jack Newhouse, who has been helping us out time and time again, helping us ever since we had our Tav Hayosher program going on, where as y'all know, it's really to advocate and be present for workers' rights. And we are so happy that our great friend Jack here is able to help us out and truly provide support during these hard times right now. So today's topic is going to be on worker rights and wages. We're going to be having a discussion here with Jack Newhouse. Please, if you have any questions, send them through our Facebook feed and/or email them to eddie@utzedek.org. And for the folks joining us on the Zoom, go ahead and drop any of your questions on the chat, and we will get to them in the closer to the ending of the event. So, Jack, thank you so much for being here with us today. We are excited to always share space with you, always share just the amazing knowledge that you have and that you provide with us. So please, Jack, go ahead and take it away.
Yeah, thanks for having me. I'm just gonna open up the PowerPoint. Give me 1 second. Share my screen. Okay, let's make it bigger. All right, everybody sees that, I hope. Okay, great. Welcome, everybody. My name is Jack Newhouse. I'm an employment lawyer, and in my field, I typically do, I represent employees in various employment-related claims. So that would be unpaid wages and also discrimination claims. And today we're going to be talking a bit about wage rights in the workplace. It's, of course, if you have any questions, please, definitely ask them. If you feel that you don't want to post them publicly to the chat, my contact information is here. It's also on the handout, which is either been handed out or will be. And feel free to reach out to me anytime, and I'm happy to answer any questions that you have. If just by reaching out to me doesn't mean you're filing a lawsuit, I promise. Okay, so before we get started, I'm going to go through a bunch of federal and New York State and New York City related wage laws. The laws that I'm going to be going through are not intended to be legal advice. Everybody has a different situation, and there are a lot of exceptions to a lot of the rules, and I'm going to try my best to sort of focus on a complete version of the law, but there are a lot of exceptions to the law, and so it's important that if you don't just apply this to you, don't go to your boss tomorrow and say, Jack Newhouse, he's an employment lawyer in New York, said this, and put your foot down, because consult with the lawyer first, and you, of course, again, like I said, you could always reach out to me. Okay, so one thing also to keep in mind as I go through my presentation is that unfair does not mean unlawful, and here's just one example of it. And so some of this is subjective, but I think a lot of us can agree that just because the law says something doesn't mean that that's what's fair to employees, and that doesn't mean that employees are paid fairly. And so one thing that I point out is that the federal minimum wage, which hasn't been changed in forever, is $7.25 per hour. If you are working 40 hours per week, 52 weeks a year, no vacation, nothing else, you're earning about $15,080 per year. And there are, according to this is from the Department of Health and Human Services, is the poverty line. And so for a person in a one-person household, the poverty line is at $12,760. For two people, which could be a single parent and a child, the poverty line is $17,240. So you have a situation here where you could be working 40 hours a week, every single week of the year. We're not talking about somebody who can't get a job. We're not talking about someone who's working part-time, but you would actually have to work on average, more than 40 hours per week, every single week of the year in order to be above the poverty line with just two people in your home. And fortunately, I'm in New York State. I know that people might be all over the place, but fortunately, there are many states that have minimum wages that are above the federal minimum wage. Like, for instance, in New York, the minimum wage, whereas in New York City, it's $15 an hour. Other places in New York State, and we'll get to this, are a little less than 15, but they're way higher than $7.25 per hour. But there are, and I made a list of them at the bottom, there are 18 states with the minimum wages that are either $7.25 per hour or lower. There are some states that have no minimum wage at all. That does not mean that you cannot pay minimum wage. If you're an employee in Alabama, employers have to pay employees at the federal minimum wage. But this is to show you that this issue with the poverty line and people earning minimum wage is not necessarily something that is hypothetical. That there are approximately 18 states. I mean, that's nearly 40% of the states where you have where the minimum wage, it'd be absolutely legal to pay people, to pay a person who's working 40 hours a week, 52 weeks a year, $12,760 for the whole entire year. Okay, so very important. Where do my rights come from? And again, we're talking about wage rights here, although it's just sort of the same for discrimination too. I'll do this backwards. Your rights primarily come from statute. And so there are statutes under New York State and federal law that talk about minimum wage, overtime, and other wage-related promises that an employee is entitled to. These statutory rights, most of them, cannot be waived, which means that if you enter into a contract with a company, the company can't say, well, you have agreed to work for $5 per hour. A company, that provision in a contract would be considered void against public policy. While there are certain wage rights that can be waived, minimum wage and overtime absolutely cannot. And so every employee, unless there is a certain exception, and I will get to some of them, are entitled to minimum wage and overtime. And I'll explain minimum wages and overtime, but these rights come from a statute, which is a law. There's also, the rights could also come from a contract. So a promise to pay a wage of $20 per hour. A promise to keep your job, right? You could have a term in your contract that says that that they promise to keep you on staff for 2 years unless you do something that is a fireable offense. Because normally under the law, we live under federal and New York State law, we live in a system where it's an employee at will system, which means that a company can fire you for any reason or no reason at all. And so it's important that if you are applying for a job or if you have a job, you should see what's been promised to you. Because another example of a right or a benefit that's been promised to you, accrued vacation time. I get this question all the time. Do you have a right to accrued vacation time if you didn't use it and you either quit or you leave? And so that really depends. Was that promised to you in that context? Is accrued vacation time only promised to you while you are currently employed? Or is it something that is your benefit, that you've earned that vacation time, and that if you were to leave, it gets paid out? And I've seen handbooks. You could look at your employee handbook. It may say something in it that if you give 2 weeks notice or if you give 1 month's notice, that they'll pay out your accrued vacation time. And that's a promise. That's a contractual promise and a right that you now have. Of course, there are certain handbooks that also say that this handbook is not a contract, in which case it's not a contract because it says so in the handbook. But just something to point out and to look out for. Before we get started, the enforcement mechanisms for if you have a wage-related case. So the statute of limitations for both wage and breach of contract is 6 years in New York State. Under federal law, it's 2 years and 3 years if willful to pursue a wage case. But one thing to note, and this is one of the biggest issues that workers are facing these days, is something called arbitration agreements. When you enter into a contract with your employer, you might sign something called an arbitration agreement. Maybe you know about it, or maybe it was just something that you just signed. But the arbitration agreement, what it basically says is you are giving up your right to pursue your claims for unpaid wages in court. And so, as you can see, the top point here says civil lawsuit. But you might, if you sign an arbitration agreement, you've now given up your right to file the lawsuit in court. You have to go through arbitration, and you have to follow the arbitration procedures. And that's probably a presentation for another time. The benefits to arbitration or lack thereof. But that's another, going back to your contractual rights, you could both get rights from the contract, and you can also lose rights, like for instance, the right to go to court. There are different ways to enforce your claims for unpaid wages. One is through a civil lawsuit, and you could do that in really two ways. One is an individual case, so you just sue on behalf of yourself, and the other one is a class action. Unpaid wage issues are very frequently brought on a class-wide basis. And the reason is because usually when there is an unlawful policy or practice, usually when someone's not paid, it's as a result of an unlawful policy or practice. So if an employee is getting paid $5 an hour and it's less than the minimum wage, usually other employees are getting paid $5 an hour and less than the minimum wage. If there's an automatic meal break deduction and everybody's working through meal breaks, that's a policy that applies to all employees. And so class actions are actually a very strong mechanism, and this has been recognized by the New York State court system, a very strong mechanism for enforcing the New York State wage laws. Other mechanisms is an administrative proceeding. So you could go to the Department of Labor, the New York Attorney General, or the New York City Comptroller and report wage theft. You could also, well, you can't file criminal claims, but the district attorney, IRS, or the New York State Attorney General could file criminal claims for wage violations. And last but not least is campaigning. And that's just kind of a less traditional approach, which is to get the laws actually changed. And that's what has happened over the last decade in New York State, especially if you look at the minimum wage for fast food workers. Okay, probably the most important slide on this page is worker classification. You kind of have to know who you are in order for which classification you fall in order to know your rights. And there are really only 4 classifications of workers. The first is an employee, and that's basically the catch-all. You are an employee if you work for somebody. That's the general rule. And the next 3 are the exceptions, unless you are an independent contractor, trainee, or volunteer. A volunteer is a person who works for free and would do something that would otherwise be considered employment work, but for a not-for-profit. And it's considered to be, and that's considered to be legal. You're allowed to volunteer for a not-for-profit institution. You cannot volunteer for a for-profit institution. A trainee. Trainee is just a fancy way of saying intern. The critical factor here is that the trainee has to be getting a benefit from the training. You do not have to pay a trainee minimum wage or any other wage at all, so long as the trainee is being supervised properly and is not doing the work that an employee would otherwise do. Yes, a trainee is allowed to do some filing here and there, or they're allowed to do some other work here and there, but the goal is this, is that you're not supposed to hire 12 trainees to take the place of 6 workers that would otherwise be required to get paid minimum wage and overtime. And last but not least is independent contractor. And when it comes to litigation and issues in litigation, this is such a highly litigated area. What is considered an employee and what's considered an independent contractor. And I'll give you just the most obvious example, which is if you are redoing something in your home, say you're redoing your kitchen, and you don't know, you've never used a hammer or you've never used a power tool in your entire life. So of course, if you want to redo your kitchen, you have to hire a construction contractor. So you hire somebody, and that person's not your employee. They're working for you, but they're not your employee. And the reason is because that person has a substantial amount of control over their own work activities. That person can hire anybody they want. They don't have to get permission from you. That person is allowed to, they could pay their workers whatever they want. They bring their own tools into the home. They're not using tools that are provided by you. That individual has a lot of leeway in negotiating what the cost is for redoing the kitchen. That individual has a lot of leeway in deciding the time period when they're going to be redoing the kitchen. Oftentimes a contractor will tell the person who hired them that, this is the time when I'm going to be working. I have other jobs. So I'm going to send this person to go work there, and then I'll come back and work on yours. And so it's this degree of control that epitomizes the difference between an independent contractor and an employee. A little bit more of a complex case is Uber drivers. That is a big deal these days. And recently, a court in California held that Uber drivers are employees of Uber, whereas Uber basically claims that they are just a technological platform, that the Uber drivers get to turn it on and off whenever they want to. They get to work whenever they want to. But on the other end of that is they don't get to choose what they're charging their customers. And so these are some of the factors that are taken into account when determining the difference between an independent contractor and an employee. Just one note on this is that independent contractors are paid, the taxes for an independent contractor are different. They get a 1099, whereas an employee gets a W-2, and there's Social Security taxes and other things that go into it. So there are implications above and beyond just minimum wage and overtime. Excuse me a moment. Okay. So going back to employee, a lot of the laws, the wage laws, apply to employees. Most wage laws that I'm going to be discussing, nearly all actually, do not apply to independent contractors. They do not apply to trainees or volunteers. And when it comes to employees, there are two different, there are two general classifications. There are exempt employees and there are non-exempt employees. And understanding the difference is critical. When I say exempt or non-exempt, I'm referring to employees that are not subject to the overtime laws, which means that you could pay them a salary. Basically, you could pay somebody, say, $100,000 a year, or $1,000 or whatever it is per week, a certain amount of money per week, in order, and if whether they work 20 hours or 60 hours, it would be legal to pay them that salary. However, just because you receive a salary does not mean that you are an exempt employee. And just because you agree, like I said before, just because you agree to a salary does not mean you are an exempt employee that is not entitled to overtime, because you cannot waive your right to unpaid overtime. So just because you're receiving you might be, I hear all the time, well, I was paid a salary. Okay, that's fine, but that doesn't mean that that's what you should have been paid. So there are certain common exemptions. The first two are executive and administrative employees. Executive employees are basically managers who are in charge of at least two full-time employees. They have to have the power or strong, or their recommendations are strongly considered a power to hire and fire. They also, in New York City, Westchester, Nassau, and Suffolk, anyone who falls under the executive exemption needs to be paid at least $1,125 per week. And lastly, they have to get paid on a salary basis. If you are a manager or an administrative employee, who I'll go through in a second, and you're paid hourly, then you do not meet the criteria to be an executive or an administrative employee. And if you're paid hourly, then that means that you have to get paid overtime. But if you're paid a salary of at least $1,125 per week, and you are a manager, and you have certain operational control over the company, and you have certain control over hiring and firing, then you are exempt and you're allowed to get paid a salary. Administrative employees are like accountants, HR, executive assistants, and these are individuals who are performing non-manual labor, and their work is primarily on the management of the business. They're not performing like, for instance, so somebody that works in human resources. And the primary job duty is that they have to be able to exercise discretion and independent judgment on matters of significance. So you might have two human resources employees. One human resource employee is making all the decisions, and the other one is maybe they're just gathering data and they're just following the direction of their boss. The person who's just gathering data is not exempt under the administrative employee exemption. They have to get paid overtime. But the person who who has the independent discretion to determine how things are done within HR, that individual is exempt. Again, so long as they're paid on a salary basis of at least $1,125 per week. Professional employees, these are doctors, lawyers, accountants would fall into that also. These are individuals who have advanced, that they performance of work requiring advanced knowledge, and they usually have higher level degrees. But there are other, that's typically how it is. And so, but the difference between the executive and administrative employees versus the professional employees is that professional employees there's no minimum salary requirement. So they don't even have to get paid minimum wage, technically. Outside sales employees also. Outside sales employees are your door-to-door salesmen. I know it sounds a bit ridiculous that, when I think of door-to-door salesman, I think of somebody who's going door-to-door selling vacuums. But that is sort of an archaic version of it. One of the more typical examples are people who are employed by financial institutions who are going out and signing people up and making sales for the financial institutions. They might go to different people's businesses to make these sales, things like that. And those individuals would be outside sales employees. And the last, and these are just the common exemptions, is the retail sales and service exemption. The retail sales and service exemption is very interesting. You have to work for a retail service provider, and that's actually a lot of places. I wrote a few of them down, like antique shops, barber shops, cemeteries, butcher shops, clothing stores, delis. I mean, anyone that sells anything retail could qualify. But you only qualify for the retail sales and service exemption if the employee also has a regular rate of pay that is equal to 1.5 times the minimum wage rate, which is not that high. The minimum wage rate under federal law, and I stress this, that when you are retail sales and service, that exemption, even if you're in New York, it applies the minimum wage of federal law. So if you are earning more than $10.88 per hour, which you have to anyways under New York law because the minimum wage is $15 an hour, and at least 50% of your wages are from commissions, then you're exempt. You don't have to get paid overtime. And you see this in many different. This could get applied in so many different ways, and it's unfortunate because there are a lot of employees, car salesmen who work many hours. If they're dependent entirely on commissions, then all they have to get paid is $10.88 per hour, basically. That's it. Okay, here's a chart of what the minimum wage is. Federal minimum wage is $7.25, like I said. But in New York in 2020, if you're in New York City, it's at least $15 an hour. In Long Island and Westchester, we're talking $13 an hour, and the remainder of New York State is $11.80. Long Island and Westchester by 2022 will go up to $15 per hour. The minimum wage when it comes to tipped employees is different. In the way that it works with tipped employees and restaurant workers is there's something called a tip credit that certain restaurants are able to take or hospitality industry. This would include hotels, also other service workers like car washes, where the employees are traditionally tipped. But the way that it works is like this. A tipped employee can get paid less than the minimum wage as a regular wage rate. So in this case, if you are working, if you're a food service worker not working in fast food, you could get paid somewhere between $7.85 and $10 per hour, even though the minimum wage is $15 an hour. And then through tips, so long as the tips make up the difference between the amount that you were paid and the minimum wage. So that would be, if you're getting 10 an hour, it would be an extra $5 per hour. If it makes up the difference, then it's legal. And that's totally legal. Not every restaurant does this, But if a restaurant does do this, they have to provide a notification to the employee that this is what they're doing, that they're receiving this tipped minimum wage at $10 an hour, and that if they don't earn enough tips to get up to 15 an hour, that the restaurant, the company, the employer will make up the difference. And one other note about restaurant employees is that the managers, non-service staff are prohibited from sharing in the tips. Tips, it's almost like a contract. When you go to a restaurant and you leave a tip, you leave that tip for the waiter, for the wait staff. And so the waiters are allowed to pool the tips amongst the other wait staff, including a waiter or maybe a busboy. But employers, supervisors that are not involved in servicing the tables are not allowed to participate in that. And so we see this a lot when it comes to restaurants and banquet halls. You'll have an automatic service charge in the contract for a banquet hall for a wedding, but it might be 15%, 20%, but that money doesn't necessarily go to the workers. This would be a wage violation. Okay, overtime. Overtime means 1.5 times your regular rate of pay when you work more than 40 hours a week. This is same in New York State or federal, under state or federal law. The regular rate is the amount that you earn per hour, including your salary, commission, piece rates. So let's just say you earn a certain amount. If you're a commissioned worker and you're entitled to overtime and you earn $1,000 a week in base, but you earned $5,000 that week in commissions, then all of that gets divided by the total number of hours you worked to figure out what your regular rate of pay is. And once you know your regular rate of pay, then you could do the math. 1.5 times your regular rate of pay is the amount that you're supposed to get paid for each overtime hour. So if you work 45 hours in a week and you're paid $15 an hour, the math works like this. You do 40 times 15. Then 1.5 times 15 is $22.50. That would be your overtime rate of pay. And you do 5 hours times the $22.50. And that's what, if you work 45 hours in a week at $15 an hour, you're required to be paid $712.50. Okay, compensable time. This is important. I mean, when are you entitled to get paid at all? And so the general rule is that you have to get paid for any hour that you work, and hours worked, it's considered, the term that is used in the law is suffer or permit. Suffer, you are suffered to work. I'll give you an example, is when you are told that you have to finish this job by 5 p.m., but you're given so much work that it's impossible to finish by 5 p.m. So you are suffered to work beyond 5 p.m. So if you work until 6 p.m. or 7 p.m., and your employer says, well, I told you you have to have it done by 5, and I did not authorize you to work beyond 5 p.m. Just because you were not authorized to work past 5 p.m. does not mean you're not entitled to money. You have to get paid for the time that you work. You were suffered to work because you had to get that done. And it doesn't matter that you had the limitation of 5 p.m. Suffer or permit, right? So if they permit you to work past 5 p.m., and permit doesn't necessarily mean that they gave you permission to work, but rather that they knowingly allowed you to work. So if you work past 5 p.m. in this example, and they didn't give you any limitation, and your supervisor's there and you're working past 5 p.m. and you're sending them emails at 9 p.m. or 1 a.m., then through that you are permitted to work. An employer, if they really want to protect themselves, have to be on top of their employees, make sure they clock in, make sure they clock out, make sure that they are not working off the clock. And it's the obligation is on the company, on the employer, to make sure that their workers are taking off and not working at a time when they are not authorized to work. So here are some examples. So commute. Oh, well, I had to commute to work. It's, they're not letting me work from home. I'm forced to commute. Well, commute time is not considered to be hours worked. It is the only time commute is considered to be hours worked is if you have to have an unusual commute. So if you normally are used to commuting from 20 minutes from your home in the city to your office in the city, but on this day, you had to go up to Albany for whatever reason, and so you go from your home to Albany, then that would be considered to a longer commute, and you would have to get paid for the time that you that sort of travel time. Travel time, it brings me to that. Once you show up to work, any travel that you do for work from the office to, say, your first stop, to your second stop, to your third stop, back to the office, all that travel time is compensatory. You have to get paid for it. Travel time is compensable. It's called portal to portal, but it does not include travel time from your office back home or travel time from home to your office. Likewise, let's just say you finish your last side of the day is you go straight from your last side of the day home. That is considered a commute home, and it's not compensable. Off the clock work, I think it's pretty obvious. If you work off the clock, you're entitled to get paid. You shouldn't clock, best practice for an employee is you shouldn't be clocking out and then continuing to work unless that was sort of an instruction to do that, in which case, there's nothing that you could do. You could stand up to your employer, but of course, there are risks to standing up your employer, and I would never tell you to just stand up to them. You do what you need to do to keep your job. Even if that means clocking out and continuing to work, and then you could consult with an attorney and see what your options are. Meal or rest breaks. If you have a rest break or a meal break that's under 20 minutes, typically, even if you're fully off, you still have to get paid for that. If it's 30 minutes or more, you have to, if you have a break of uninterrupted break of 30 minutes or more, then you don't have to get paid for that. However, if you have a 30-minute break and you're constantly being interrupted, then you have to get paid for it. And this happens very frequently with like, say, nurses, especially those working in the emergency room. You may have something comes up while you're eating your lunch. You have to get up and go do it. Then you come back, you're 10 minutes in, you're interrupted, you come back, you eat your lunch for another 10 minutes. That becomes fully compensable. The problem is that a lot of the software that is used to calculate the hours worked, a lot of companies use automatic deductions. They automatically deduct 30 minutes or 1 hour, whatever your lunchtime is. And then they'll say, okay, employee, come to me and tell me if you worked through lunch. And obviously employees aren't going back and reporting it, at least in my experience, they're not doing that. So that results in a lot of lost time. So if there's automatic meal break deductions, but you're working through your meal break, then that is time that you're owed. On-call time. On-call time, you have to get paid for on-call time if you are limited. So a good example of certain limitations, let's just say you're a bus driver. You drive kids to school. And so the bus company says, after you drop off the kids in the morning, you have a 3-hour break. You could go do whatever you want during that 3-hour break, and then you have to come back and pick the kids up from school and bring them home. That is not compensable. You're not entitled to wages for that time because you're free to do whatever you want. But if the bus company says, no, you have to wait at this particular spot and stay by the bus in order to protect it, then that would be compensable time because you're not free to go do about whatever you want to do. Show up time is if you show up to work at this happens a lot with, say, a moving company or even other types of busing companies. You show up at 6 a.m. because the company is deciding how many people it needs. It may not know each day how many people that it needs. And so you're instructed to show up at 6 a.m. And so you show up at 6 a.m. and by 6:15, 50 people are chosen, but not you. And so you're sent home. In that situation, an employee has to get paid for the lesser of, I believe it's either 2 or 4 hours, depending on the industry, and or the shift, whatever the normal shift is, the lesser of the two. So if you were instructed to show up and you're told to go home 15 minutes later, you're still entitled to some wages. Deductions under New York State, under federal law, there is no law prohibiting deductions other than deductions into your minimum wage. So if you are getting paid $7.25 per hour, which will not happen in New York, or it shouldn't, then if your employer deducts a certain amount of money from your wages, and that means it cuts into your minimum wage. So there's a violation there. But under New York law, there are very limited permissible deductions, tax withholdings, overpayments due to mathematical errors, deduction, and the last one, and this is important, deductions that benefit the employee, but not just benefit the employee, they also have to be signed written consent. So you see this with union dues, insurance premiums, pre-tax commuter benefits, and retirement funds. So if your insurance premiums are taken out of your check each week or bi-weekly, but you didn't, and you're working in New York and you didn't authorize for the insurance premiums to get taken out, that would be a violation. A company's not allowed to just deduct insurance premiums without your consent, even though the deduction of the insurance premium is for your benefit. You still need signed written consent from the employees. Here are a couple of interesting wage entitlements that a lot of people don't know about. If you're paid at the minimum wage in New York, there's something called spread of hours. So if you work more than 10 hours in a day, you have to get paid 1 additional hour's pay at the minimum wage rate. So if you're paid 15 an hour, you work 11 hours, you get paid 11 hours times $15 an hour. And then you could get an extra hour's pay at $15 an hour if you worked 11 hours. That's what spread of hours is. Spread of hours, you don't have to work 10 continuous hours. So let's go back to that bus driver example that I gave a moment ago. If you pick the kids up at 6 a.m. and you drop them off, well, you're finished dropping all the kids off by 10 a.m. and then you have to pick the kids, you don't work for 3 or 4 hours in the middle of the day. And then you're picking the kids back up and you're returning them, and your day really ends at 5 p.m. So that's an 11-hour day. Even though you didn't work for 11 hours, the driver is still entitled to spread of hours, of course, so long as the driver is getting paid at the minimum wage rate. Uniform maintenance. Uniform maintenance is if you have to get paid at the minimum wage rate, but if your company requires that you wear a uniform, then the company is required to pay for either to launder and maintenance the uniform or to pay a certain stipend, which if you're a full-time employee in New York City, I think the stipend these days is about $18 a week for laundering and maintenance of the uniform. The stipend depends on the number of hours worked, the location where you work, and things like that. But if you're working in New York City, over 30 hours a week, the stipend is about $18 per week. And that's because you have to wash your uniform in order to for the job. One note, when it comes to one interesting note is that when it comes to restaurant workers, spread of hours and uniform maintenance apply even when the restaurant worker is earning more than the minimum wage. So all restaurant employees are entitled to spread of hours and uniform maintenance. Okay, another interesting area which I just wanted to point out is home health aides. Home health aides are a pretty exploited class of workers where there are these 24-hour shifts, but they're only required to be paid for 13 hours. And so, is this legal? Yeah, it is legal, but there are certain very strict requirements. And one is that they get 3 uninterrupted meal breaks of 1 hour each, and 8 total hours sleep, 5 hours uninterrupted. And I don't know if anybody here has any relatives that have had a home health aide, or if you've had one yourself. But typically home health aides do not get a full night's sleep. Typically they have to get up in the middle of the night to assist whoever they're caring for. And so what you have is a situation where these companies are paying people for 13 hours at the minimum wage rate, and they're really working like 19, 20 hours a week. I mean, 19, 20 hours a day, which is pretty hard. Certain home health aides are entitled to New York City living wage, which is $10 an hour and $1.50 in benefits, which is unusual because it just hasn't been updated because the minimum wage is $15 an hour in New York City and higher than $11.50 in basically everywhere in New York State. However, there is something called the Wage Parity Act. So if a patient is receiving Medicaid or Medicare funding, there are certain wages that have to get paid. So if you look all the way at the very end, which is December 31st, 2018 and beyond, the base rate of pay is $15 an hour. But in addition to that, there has to be a supplemental wage, which could be paid in the form of benefits in the amount of $2.40 per hour, plus an additional wage, which could be paid through other, doesn't have to be benefits, but maybe a Metro card, things like that. Or it could be paid in cash. So that's $1.69 an hour. And so you have this, so if you have a home health aide that's employed through Medicaid or Medicare funding, it's important to note that there's a higher minimum wage for those employees. This is a very recent law, the Freelance Isn't Free Act, that is actually its name, where these are referring to independent contractors now, where if you hire an independent contractor to perform services, film and video employees, web design, home contracting and repair, media, photography, translation services, you could imagine there are a lot of services that fall into this category. They have certain entitlements, and one is they're entitled to a written contract. And they're entitled to timely payment and full payment. And they're entitled to protection from retaliation. These are above and beyond, way above and beyond what independent contractors have ever been entitled to under the law prior to 2017. And one of the benefits of this law is that the court could order double damages. So instead of a breach of contract resulting in just damages, whatever the damages were under the contract, the courts can actually order liquidated damages, which is double damages. So if you're at $10,000, the court could order that that you have to pay $20,000 if you breach the contract. Okay, we're wrapping up here in a couple minutes, but these last few slides, I saved them for the end because I think that they're so extraordinarily important. This and the next one. These are the wage hiring notice requirements in New York State, and then the other one's a wage statement requirement. And this is really the key, because if employers complied with this, this is the way employees are informed of their rights, what they're being paid, and so it doesn't matter whether you're exempt, not exempt, a tipped employee. There's different versions of these on the internet, and they have to be given to employees in their primary language, which could be English or any other language. And it also has to indicate the rate of pay, allowances taken, overtime rates of pay. If there's for restaurant employees, there's the tip minimum wage. It has all the information you need to know to understand what you're going to be paid. And this wage hiring statement, coupled with the wage statement, which is essentially a pay stub, shows an employee, okay, well, we're paying you $15 an hour times 42 hours in a week, and your overtime is going to be based on 2 hours, different things like that. And if employees receive these wage statements, then they know they're getting paid correctly. It could be that if an employee doesn't receive a wage statement and they just get a random sum of money, it's hard for an employee to really know whether they're getting paid correctly, especially if they're not keeping track of their time worked. Which of course brings me to how to protect yourself. Keep records. If you think that you're being underpaid or any other issue in the workplace, write it down. Write down when you worked, where you worked, how long you worked, the type of work that you did, and how much you were paid. These notes will help in the future, help you combat these unpaid wages. And remember, you have 6 years in New York State to file an unpaid wage claim. So it's not as if you have to file something right away. And so it makes it all the more important to record this information down. And then you could contact the appropriate government agency or go to an attorney to discuss your potential concerns. A lot of employees, such as my firm, we do free consultations, and everything is privileged and confidential. So it's almost like you're getting free advice, honestly, and then you could decide what you want to do. And the last bit of advice that I'd say is be careful, because even though retaliation is illegal, you could speak up. You could say, I don't think I'm getting paid properly. I should have gotten paid overtime, but you didn't pay me overtime. At the end of the day, it's about you. and it's about your family and being able to support your family and support yourself. And those are very important concerns. And it's any lawsuit that you bring, it's your lawsuit, not the lawyer's lawsuit. And so it's very important to recognize that even though retaliation is illegal, it still can happen. And if you are raising an employment dispute with a company, I would assume that they're going to retaliate against you in some way, either obviously or not so obviously. And so you have to really be cognizant of that as you whether you decide to raise an issue. And again, you could reach out to a lawyer. If you reach out to an administrative agency, they won't give you advice. They'll just pursue the claim. But if you reach out to a lawyer, they certainly if you reach out to my firm, but if you reach out to a lawyer, they may give you advice and tell you what they think will happen, and then you can go from there. Okay. If anybody has any questions, I would absolutely be happy to answer them.
Thank you so much, Jack. I'll start off with some of the questions from online that we have. In questions of the current climate right now that we have with COVID and the pandemic, what do you recommend when folks are kept on as they aren't fired technically, but they're kept on as with 0 hours? Should folks seek any sort of legal advice if they're simply not getting paid? But at the same time, they can't file for unemployment because they're still employed.
I disagree. You could if you're working but not getting paid. Unemployment is tricky. It depends where you live. But in New York State, you could file for unemployment if you have a reduction in the amount that you're being paid, and you should file for unemployment. Because under New York State, you might qualify under New York State for unemployment, but even if you don't, there's pandemic unemployment relief, which the extra $600 a week actually expired on July 31st, but you still can get New York State unemployment if whatever you would be entitled to under New York State unemployment. It's less than $600 a week, but you can still get that if you are not working any hours, but you're, say, furloughed by your company.
Thank you. Another question is, how can one advocate for tips that are taken from an employer?
It depends how you want to advocate. You can, one way that I would not generally recommend is by, going straight up to your employer and saying that I wasn't paid tips. Let me see your books, because I can almost promise you that if that employer is stealing tips from you, they're not going to show you their books, and they're probably going to retaliate against you. So the best thing for you to do is to try to keep track as best as you can of the tips that are being earned, that you've seen. So if there's an automatic service charge on the receipt, try to write down or take a picture of a receipt that shows what the automatic service charge is. Try to recall how much in tips your tables earn, or how much in tips were earned total over the course of the day, and then try to extrapolate from there when the tips are being divided up at the end of the week. If there's a tip pool or other type of tip arrangement, try to figure out whether the tips are being divided in a proper way, or whether maybe there's some that's not really being distributed properly. And then you will have a better idea, and you should definitely write that down for a few weeks before addressing your employer, because you're going to want to get the proof first. And again, it's hard for me to say here on the, what you should do next, but my advice really is to reach out to an attorney and to get specific legal guidance and help.
Thank you. Another question is, do folks who are undocumented have the same worker rights as folks who are documented?
Excellent question. When it comes to wage rights, workers who are undocumented have the exact same rights. An undocumented worker, in fact, an undocumented worker brings a case, New York State and federal law are very protective of a worker's immigration status, to the point where an employer is absolutely positively not allowed to ask any questions relating to an employee's immigration status in order to prevent them or scare them into dropping the lawsuit.
Thank you. Another quick question is, if is there legal action that must be taken if folks are continuously not getting paid overtime?
That must be taken. I suppose it doesn't have to be taken, but if there are employees that are entitled to overtime that are not getting overtime, then those employees would have the right to bring a case either individually or if it meets the criteria for a class action to help recover those unpaid wages that they should have received.
Thank you. Now another question here. Question is about paid time off. If on contracted paid time off was agreed upon, and then both parties decide to vacate after years worked, is that paid time off? Can that be recuperated? I think is what they're asking.
Yeah, I understand. Yeah, I mentioned this earlier about the accrued vacation time. It would be the same for paid time off. So it depends how it's structured in the contracts. Unless there's some sort of promise that says that you are entitled to paid time off or to payouts of accrued paid time off after you leave, you're not entitled to it. It has to be a contractual promise for that benefit. And again, I'd be happy to, if my contact information is there, if you have a specific question about the terms of your contract, feel free to reach out to me.
Thank you so much, folks. For those of you on the call, if any of you have any questions, please feel free to drop them below. I'm getting questions that are being sent to us from our social media platforms, etc. Jack, thank you so much for this great presentation. As always, you are extremely helpful. And I know that a lot of people, apart from everything going on in the world right now, it would be super crummy to have to deal with this kind of issues right here. Okay, let me look for more questions here, Jack. Thank you so much for your amazing time. Okay, another question here, Jack. If an employer is paying below minimum wage and is hiding it, is there a way to advocate and seek legal support without repercussions?
Hard to say. It depends. It's hard to bring a claim anonymously. You can't bring a lawsuit anonymously, that's for sure. I would certainly I'll bring that slide back up just so that's here. I would definitely keep records of all this information because that'll help in the future. You have 6 years under New York state law, 2 to 3 years under federal law in order to bring the claim. There are different ways to help change the situation. One of them is a class action, not necessarily brought by you, but if there's a former employee who's not afraid of any retaliation because they no longer work there, that employee could technically bring a class action to help all the other employees who are getting paid less than the minimum wage. Sometimes you could file a claim with the New York State Department of Labor. You could file it anonymously, but I don't think that it really ends up being anonymous.
Thank you. Yeah, and I think a lot of people fear that like retaliation, and I think that a lot of the times that's what stops folks from really seeking legal support. So thank you for that. Well, thank you so much, Jack. We've reached the end of our time. We appreciate it. Once again, Jack, how can we reach you if we have any more questions? How do we get in contact with you?
Sure, I'll share again. Okay, here we go. My email address is jnewhouse@vanda, VANDALLP.com. My office number is 212-943-9080, but we are operating remotely more or less still. So you could get hold of me directly at 914-719-6656. And that's 914-719-6656. And if I don't answer, just shoot me a text message because I don't always pick up unknown numbers.
Thank you so much. And once again, we appreciate you, Jack, for stepping in and helping Uri L'Tzedek fight for workers' rights and be there We really appreciate all of your work, and we're hoping that you're staying safe. And everybody who joined us on the call today, stay safe. Thank you so much for joining us. We appreciate you. If you look for the recordings, it will be on our website. That way you can share and distribute. Sometimes a little bit of information like this saves so much money, time, and hassle. So we appreciate you, Jack. Have a great day.
My pleasure. Thanks, Eddie. Be
Bye-bye.
well.